Hi my dragons, hope you're doing well today, and I'm making this video in 3 parts to cover the victimology stuff that I want to go over for the chapter. So here's the first part, and I'm going to go over piece by piece what's important. So the first part, which is the history of victims' rights, and then a big thing on the victim impact statement, and then cases and conclusions. It's just a long chapter with a lot to go over, so let's get into it. So one of the things that was happening in the United States, again, we talked about the fact that it's the criminal justice system and not the victim justice system, is that throughout history, the Supreme Court and the law of the land has succeeded in alienating the victims from the process, which has left the victims disillusioned with getting justice in the court system. So one of the things that was proposed right off the bat was a victim right amendment. And they wanted at first a federal amendment to say that victims should have different types of rights. And they thought that the best way to do that would be to actually change the wording of the Sixth Amendment so it would extend more to crime victims. So all it would take was another sentence, and if you can find this change on page 135 of your textbook. And so you have the Sixth Amendment, and this is what they wanted to add. Likewise, comma, the victim, comma, in every criminal prosecution shall have the right to be present and to be heard at judicial proceedings. So those two things are very important, not only to be present, but also to have their say about what happened in the crime and how it affected them, and therefore what they feel is just for them. Okay, so remember, victims have suffered. It's not their fault that they've suffered. So they want to have a say, okay, over what is happening. So this attempt to modify the Sixth Amendment met with some critical bumps in the road. So that's what you're going to see. Every attempt that we had to try and put forth more victims' rights met with criticism and opposition. So it became a long and difficult path, and we've reached sort of a solution today, but it's not quite as all-encompassing as the victim rights advocates wanted. Okay, so they thought it was too difficult. They thought it was going to be too slow, and it was going to take too much time and be too tedious. So then they scrapped the idea of modifying the Sixth Amendment, and they said, okay, why don't we just, have a whole nother amendment to the Constitution. We have a lot of amendments to the Constitution. The Constitution was made to be changed and amended. Let's just make a new one. And so that, of course, became a point of resistance as well. And one of the things, ironically, that they said was that there would be a lack of uniformity from state to state, and it would be vague and overly encompassing, and they realized that this would be impossible as well. So the next strategy was, let's just go to states and see if we can have something done in each state that is kind of overarching for all the states, but then every state can build in their own unique wishes for their victims, to deal with their victims. So the National Victims Constitutional Amendment Passage, or NVCAP to be short, to shorten it up, they decided to target different states for, doing this. And they thought it would be better to go state by state than federal. So this was because, number one, they thought it would be better at the local interest, that there would be more interest and more support. More people would say, yeah, let's do that. Second, they thought that some states had victims' rights on the books, so some states could just expand what they already had. Some states, they would have to really put in a lot. They also thought that because state constitutions already protected criminals, it was reasonable to, just bring it over to the victims as well, because if the defendant has certain rights, then the victim should have it as well. So at this writing, there's no federal constitutional guarantee for victims' rights, but every state, starting with California, so California was the first in 1982, They have all approved, not all, but 36 states have approved some sort of constitutional measures, and the rooster is going to come over in a minute. So there you go. Anyway, so they're trying to get common rights, and they have had pretty good success from state to state. The problem is always the same problem with victim compensation. Most victims, for whatever reasons, are not aware that these things exist. And so it's important for victims to know these things when they find themselves all of a sudden thrown into a criminal proceeding. So one of the things that was suggested that I think was really good was that police officers carry a card, just like the Miranda card. It could be like two sides. And then when a crime happens, they're giving the defendant their Miranda rights, and then they go to the victim and say, here are your rights as well. So it would serve to educate the victims of crime so that they would be ready for what inevitably would be a court situation that they would then be placed in. So this too, believe it or not, met with some resistance. And they said, well, the thing is with victims' rights, that tends to be more gut level than, thought out processes. Some people might want this because it's a lock 'em up philosophy. And then third, this is the criminal justice system, and it may erode the rights of the defendants in this case. So that was really kind of interesting that they did this. They also were afraid that if they passed such a thing, there would be a lot more cases coming up before them. So when they passed the civil rights cases, civil rights law, there was a concomitant increase in the number of civil rights cases. So that was really interesting to do. So they're trying to rekindle this constitutional reform, okay, to see what they can do for victims' rights. And then there was something that happened that really rekindled it, and that was the Oklahoma City bombing. So you remember Oklahoma City bombing came before 9/11, and it was a big terrorist attack upon our country, but it was an internal terrorist attack. In other words, we were attacked by a homegrown terrorist, one of our own. And what happened during the Oklahoma City bombing was that there was no mechanism in place for the victims to be heard, to say what they thought. And when they wanted to press to be heard at court and to attend the court proceedings, the judge during the court proceedings said, you'll have to choose one or the other. You can come and not say anything, or you can wait till the sentencing part of the trial and then say something. That last part where you stand up and say something is called allocution. So you could be present or you could do allocution, but you couldn't do both. So this was another thing that went through a long process, and there was a lot of fights over it. So you probably don't realize this, but in the United States, we have a jury system, and the jury system is one of two types. They're either recommendational by state law or they're decisional. A recommendational jury recommends to the judge, and then the judge says yes or no, I'm going to do what the jury says. A decisional jury has the final say, and no one can overrule it except for an appeals process, a Supreme Court, something like that. So they have two different kinds of juries, and that's an interesting thing that they discussed as well. So it went through a lot of trials and all of this kind of stuff, and even there was a Victims' Rights Clarification Act of 1997, which said, okay, you can have victims either, in non-capital cases or in capital cases, and that's all that you can hear them. So as you can tell, that didn't sit well with the victims' rights people. So Congress then passed the Victim Rights Clarification Act. That was that. And so that resulted in breaking up when you could hear the case, okay? Today, victims can watch the trial and they can be there for allocution. But there's some states break it up between you can be there for the whole trial, but you can only speak during the sentencing part. And they think that this is a better mechanism to protect the rights of the defendant. But that will have changed, and we're going to go into that when we get to the case part of this chapter. So that was a really good decision that stood for quite a while. But they tried and failed, kept trying for a constitutional amendment. And they had on page 143 a proposed amendment, which you can see what that looked like in 2015. So then this began the era of victims' rights legislation. So they decided, we're just going to write this legislation in and see what DOJ, Department of Justice, wants to do. And you can go to the DOJ website. I'll put up a link in the Moodle so that you can see what they're doing. I'll also put up a link to what Ohio does as well. So the federal regulations came out, and I'll take a picture of this and put this up in a picture part of the Moodle as well. The federal regulations, it's the Federal Restitution and Rights Act of 1990, and it lays out federally what the federal government does for victims after this passed. And the Federal Crime Victims Act in 2016 was established that gave victims' rights in criminal cases, not in civil cases, which was very interesting because civil cases can have victims, and those crimes can be very devastating to people, like identity theft or something like that. So as it exists, we only have right now for civil cases, criminal cases, I'm sorry, not civil cases. So that, I think, is something that is in the works, right? So there was a case, Kenna versus the District Court, U.S. District Court, in 2006, and this was a father and son investment firm, okay? So here we are talking about investments, which is essentially a civil case, but they were going for civil and criminal charges. A father and son investment firm that bilked people out of their life savings, so many people, and they bilked them out of almost $100 million. So that was a lot. So the victim impact statement, several victims came forward and imposed their right of allocution and said, hey, they bilked us out of a lifetime's worth of retirement savings. Their businesses were bankrupt, their lives were ruined. And then the jury sentenced the father of the father and son to 20 years in prison. Now, what happened after that was the son also faced charges in this case, and the victims wanted to add their thoughts about what should happen to the son. And the judge denied it and said, I don't think there's anything more I need to hear about this. I've already heard what happened with the father. What more can you say about the son? Well, the victims then filed a mandamus action, and a mandamus action is a demand. It's a demand for the court to be heard. And they filed a mandamus action under the Victims' Rights Crime Act and said that they demand allocution in this case, and they demanded that they should be heard. And it was very interesting because the appeals court agreed and said, yes, you have the right to be heard. And what happened was the son then got 11 years of imprisonment after that. So they had to file that and go through all of that. And then, what would happen in the next case that comes up like that? And this was in United States versus Wood. Wood had been found guilty of fraud, and he was going to go into a sentencing hearing. And what happened was the plaintiff was going to be out of the country, and the plaintiff said, hey, I'm going to be out of the country. Can we postpone this hearing so that I can be there, not only for the trial, but for allocution as well? And the court literally agreed and said, yes, we can delay it and we can accommodate you. So that was, in essence, holding up the findings in Kenna. So the courts, you see, are moving toward more inclusion of victims being heard at this point. It's really actually pretty good. So what we see now is states moving toward hearing from victims on these different cases. So another thing is they left it up to the states to notify the victims. So this happens through victim services or prosecution. And what happens if they can't get a hold of the victim to say, hey, here's when the case is going to happen. Do you want to be present? Do you want to be heard? And what happens is there's no punishment for not getting a hold of the victim or for the victim not coming to the court. But what they say is, well, if as long as the prosecutor's office or the victim's services office has made an honest and reasonable attempt with no malice, then it's okay. So what happens if the victim still feels like, hey, I didn't know about this and I still blame them? Then their only source of appeal would be to the state, and every state has an ethics board. And then the ethics board can go to those entities and punish them for not making a good enough attempt. Okay? So that's a pretty good solution. Another thing that they can do, and a lot of states have done this, is to follow in the footstep of other agencies. So a lot of agencies have what's called an ombudsman. And an ombudsman is a state-appointed neutral party who hears complaints and then makes referrals, recommendations to judges and other decisional authorities as well. And this is only in a few states, but it's a good kind of mediation that you can go through as well. Some of the critics of that is that it focuses too much on the victim, or it will, again, diminish the offender's rights, and we don't have room in prison for all of these different things that are going on. So that's a very small nutshell. I do expect you to read the chapter because it goes into better detail about all the attempts that were made to gain these rights. The next part will be the victim impact statements, and this is what they're all fighting about. So that will be part 2. I'm going to do that in a minute.